Let's dig a little deeper now with former prosecutor and criminal defense attorney Bob Bianchi. So, Bob, when I look at this, there's a couple of things that stand out to me. Number one, there's clearly no parent-child privilege, but there is some sort of a privilege when it comes to testimony if you are the spouse, correct? Is that different?
There is spousal privilege, as patient-doctor privilege,
right? Attorney-client, obviously.
Attorney-client,
right?
But there is none for parents and their children. So they can't rely on that privilege to say that we won't speak to you.
Right.
And Florida does something very interesting with the prosecutorial subpoenas. They have a law that you usually can claim, I have a Fifth Amendment privilege against self-incrimination because I may say something that can get me in trouble. But they have an immunity under the law that says any information you give to the prosecutor pursuant to the subpoena cannot be used against you, and that stops the parents from making that argument.
Right, but the concern for these parents, obviously, is I'm not so concerned about being used against me as the parent. They're saying we cannot bear the thought of anything we say being used to convict or even execute, in their words, our son.
And listen, I get it. I've done death penalty cases as a prosecutor, and I feel bad for these parents. They're not the ones who did this. But the prosecutor has a job. 4 people are dead. It's probably going to be a death penalty case. And the prosecutors want to do this not so much to prove he did it, but when you get to the penalty phase, there's things called aggravating and mitigating factors that the jury will consider as to whether to execute or not. Knowing his state of mind, knowing what was going on in his life at the time is crucial for the prosecutor, even to make the decision in the beginning, Erica, as to whether or not by law they should be pursuing a death penalty case in the first place. So say, for example, they find out that he was having a mental break. He was having some sort of psychotic episode. That would tend to make them not want to file a death penalty case. They need to know this data now.
It's interesting because you would imagine, perhaps not, but one would imagine that if it were something to that effect, if their son was having mental health issues, that's something that in some ways could, to your point, perhaps lessen the charges.
It could do 2 things. It could actually be a defense to the actual crime itself, but certainly any mental health or emotional issues at the time of the penalty phase could warrant not giving the death penalty.
So the judge wants them to prove why they shouldn't be held in civil contempt. Is that correct?
That's right.
Right. How do you prove that?
Well, subpoena is, in essence, really a court document that prosecutors are allowed to use. The prosecutors are saying we're using it appropriately. They don't have a privilege that we just talked about or an immunity to prevent them from speaking to us. They've refused to speak to us. And the court basically went very slow here today. They basically said, because the court doesn't want to be jailing these parents or fining them. So they said to them, listen, we're going to give you to January. And if you still refuse to cooperate, I need to know why. And the next thing is going to be the judge is going to say that's an insufficient reason. You either cooperate or you get fined or go to jail.
So what are the chances you think that they would actually go to jail?
This is a tough call. It's going to really depend on the reasons that they're going to provide to the court. But if it's going to be simply that I don't want to testify or give evidence against my son, the judge is going to do what the judge feels is necessary to get them into compliance. In other words, the idea is, we'll put you in jail or we'll fine you.
What else is there to sweeten the pot, though? If they're going to do what's necessary. I mean, we're already saying, okay, you have immunity, so, you know, nothing you say is going to incriminate you in any way. I mean, what else can they say that will actually compel, do you think, these parents to, of their own will, say on January 4th or 5th or before, okay, here you go?
What I would do as a judge is I would sit there and say, as of today, you're in contempt of the court. You're in contempt of the subpoena. Fine. You have 10 days to come into compliance. We recently talked about a case like this. If you don't come into compliance, the next step is the jail for, 30 days, 60 days, or maybe even up to 6 months. So I think the lawyers are going to eventually say to them, the defense attorneys or the lawyers that they have hired, listen, you need to comply or you're going to jail. And they may say, you know what? I'll go to jail. I've seen it happen. And they sit there and they say, we refuse to cooperate.
How long did they sit in jail?
Well, I've seen people sit for up to 6 months or longer
6 months?
waiting to come into compliance. But I have seen ultimately, really, the judge eventually gets to a point where he's like, look, it's clear that jail isn't working and there's nothing more we can do. And eventually they get released.
Wow. All right. We'll continue to watch it. Always good to see you, my friend. Thanks, Bob.